Hello friends, I welcome you all to today's lecture on capacity in law of torts. In this lecture, we will be discussing capacity of person in law of torts to sue and to be sued, with special emphasis on persons having judicial authority and persons having parental and quasi-parental authority. Persons having judicial authority. There are special laws which provides protection to judicial officers with basic aim to enable judicial officers to administer law without any fear of being brought to litigation against them. Such laws provide protection to judicial officers and immunity against litigation, which is called judicial privilege. Halsbury Laws of England explains about the judicial privilege as, I quote, "The object of judicial privilege is not to protect malicious or corrupt judges, but to protect the public from the danger to which the administration of justice would be exposed if the persons concerned therein were subject to enquiry as to malice or to litigation with those whom their decision might offend. It is necessary that such persons should be permitted to administer the law not only independently and freely and without favor, but also without fear." Unquote. Further, it lays down, whenever the protection of the exercise of judicial powers applies, it is so absolute that no allegation that the acts or words complained were done or spoken malified, maliciously, corruptly, or without reasonable or probable cause suffices to found an action. No such protection is granted if a magistrate is acting malified and outside his jurisdiction. In Anwar Hussain versus Ajoy Kumar Mukherjee, it was held that judicial privilege is absolute provided that act done by him in discharge of his judicial duties was within his jurisdiction. The same protection is also granted if at the time of the act complained of he was acting out of jurisdiction, provided that he in good faith believed himself to have jurisdiction to do or order the act. In India, laws provide protection to judicial officers for any act done or ordered to be done by him in the discharge of his judicial duty. According to Section 1 of the Judicial Officers Protection Act 1850, I quote, "No judge, magistrate, justice of peace, collector, or other person acting judicially shall be liable to be sued in any civil court for any act done or ordered to be done by him in the discharge of his judicial duty, whether or not within the limits of his jurisdiction, provided that he at the time in good faith believed himself to have jurisdiction to do or order the act complained of, and no officer of any court or other person bound to execute the lawful warrants or orders of any such judge, magistrate, justice of peace, collector, or other person acting judicially shall be liable to be sued in any civil court for the execution of any warrant or order which he would be bound to execute if within the jurisdiction of the person issuing the same." Unquote. In state of Uttar Pradesh versus Tulsi Ram, the question which had arisen was whether a judicial officer who negligently ordered the wrongful arrest of a person could be liable for the wrong of false imprisonment. In this case, 5 persons were prosecuted for certain offences. One of them was acquitted by the Sessions Court and another was acquitted by the High Court. The High Court upheld the conviction of only 3 of the 5 persons and authorized the issue of warrants against these 3 convicted persons. The judicial magistrate, acting negligently, signed an order for the arrest of all 5 persons. As a result of this order, the plaintiffs, even though they had been acquitted by the High Court, were arrested by the police. They were lodged in jail at 2 p.m. and released at 3 p.m. They filed a suit claiming compensation from the judicial officer, stating that their arrest before their relations and friends on the day of festival had caused much humiliation, physical discomfort, and mental suffering to them. On an appeal, court held that state was not liable because the act done by its servant was in discharge of his duties imposed by law. The High Court, on the other hand, held judicial officer liable for the wrongful arrest of the plaintiff. It was held that the judicial officer was not exercising any judicial function but only an executive function while issuing warrants, and therefore the protection under the Judicial Officers Protection Act 1850 would not be available in this case. It was observed, I quote, "He, that is judicial officer, signed the warrants without looking into the orders of this court or the directions of the sessions court or even his own orders. He failed to apply his mind to the facts of the case or to directions given to him. It cannot be said that he was protected at all by the Judicial Officers Protection Act in signing warrants negligently." Unquote. Persons having parental and quasi-parental authority. Generally, the law is that punishments can be administered to children by parents, teachers, and guardians to prevent them from committing wrong to others or themselves. This power is delegated by parents to teachers when children are admitted to schools. However, the excessive use of force is never permissible, and in such cases they may be liable for assault, battery, or the false imprisonment as the case may be. So far as the liability of parents for the tort committed by child is concerned, ordinarily a parent is not liable for a tort committed by a child with certain exceptions, such as knowledge of the parent about the mischievous or dangerous capacity of the child, tendency to set things on fire. The parent could be liable if the parent did not take reasonable steps to prevent such an occurrence. Such steps could be getting psychological counseling for the child or watching the child very thoroughly. If a child is a reckless driver and the parent knows that the child is a reckless driver, the parent might be liable if the child uses the parent's car with the parent's permission and causes an accident. This is called negligent entrustment. Parental and quasi-parental authority or persons in loco parentis may, for the purpose of correcting what is evil in the child, inflict moderate and reasonable corporeal punishment. Under Old English law, Children and Young Persons Act 1933, certain rights were given to quasi-parental authorities, where the status of the authority of a schoolmaster during the school hours was the same as that of the parents. When a parent places his child within a school, he delegates him all authority so far as it is necessary for the welfare of the child. Teacher can inflict moderate and reasonable punishment on his pupil. In the case of Rex versus Newport, Justice Wright expressed that the schoolmaster has his own independent authority to act for the welfare of the child. This authority is not limited to offences committed by the pupil upon the premises of the school. It may extend to acts done by the pupil while on the way to and from the school. In this case, there was a rule in the school prohibiting smoking by pupils whether in the school or in the public. A pupil, after returning home, smoked a cigarette in a public street, and the next day the schoolmaster administered to him 5 strokes with a cane. It was held that the father of the boy, by sending him to the school, authorized the schoolmaster to administer reasonable punishment to the boy for breach of a school rule, and the punishment was reasonable. The quasi-parental authorities cannot exceed their control over children in such a way to inflict injuries on them. we observe an increase in the number of complaints over last few years whereby the parents and guardians are seeking damage for injuries suffered to their children at school. These suits usually are filed against the schools and school personnel. Such complaints often involve injuries, either physical or emotional, that occur either accidentally or intentionally. In such suits, plaintiffs seek monetary compensation for the injury suffered. These awards may take the form of compensatory and punitive damages. Compensatory damages are compensation for actual losses, while punitive damages are monetary awards to punish the defendants for wrongful actions and to deter such actions in the future. Quasi-parental authorities have liability for the injury suffered by child either negligently or intentionally. It is observed that the torts committed by the quasi-parental in educational institutes is often related with negligence. The difference between negligence and an intentional tort is that in negligence, the acts leading to injury are neither expected nor intended. Students who bring negligence claims must prove that authorities should have foreseen and prevented the injury by exercising proper care. Accidents that could not have been prevented by reasonable care do not constitute negligence. Some elements which are necessary to constitute the tort of negligence includes: the quasi-parental authority must have a duty to protect students from unreasonable risks. The quasi-parental authority must have failed in that duty by not exercising a reasonable standard of care. There must be a causal connection between the breach of the duty to care and the resulting injury, and there must be an actual physical or mental injury resulting from the negligence. In a court, all four elements must be proved before damages will be awarded for negligence. In the year 2001, a public interest litigation was filed by Parents Forum and Meaningful Education, challenging the provisions of the Delhi School Education Rules 1973, providing for corporeal punishment to a student. The Rule 37 states the form of disciplinary measures, as may be adopted as detention during the break for neglect of class work, but no detention shall be beyond school hours. Secondly, to those students who attained age of 14 years as a fine, expulsion and rustication. It states that corporeal punishment may be given by the head of the school in cases of persisting impertinence or rude behavior towards teachers, physical violence, intemperance, and serious forms of misbehavior with other students. It contains some exceptions, like corporeal punishment should not be inflicted on the students who are in ill health. It shall not be severe or excessive and shall be so administered so as not to cause bodily injury. The government justified the rule as necessary for inculcating discipline. The Division Bench of Delhi High Court held that corporeal punishment was not keeping with a child's dignity. Justice Anil Dev Singh and Justice Mukundakam Sharma said that it was cruel to subject a child to physical violence in school in the name of discipline and education. It was held that inflicting physical punishment on a child is not in consonance with his or her right of life guaranteed by Article 21 of Indian Constitution. It was observed, I quote, "Just because child is small, he or she cannot be denied of these rights. Even animals are protected against cruelty." Unquote. The court also said that there had been instances where children had been traumatized and beaten in schools, causing grave injuries to them on account of their innocent pranks, mistakes, and mischief. In 2003, Tamil Nadu Education Minister advised parents to pursue remedies for mental and physical torture, the schools were instructed to avoid corporeal punishment. A 5th standard student was allegedly caned for being a slow writer. New set of revised Tamil Nadu education rules had been framed, wherein the Rule 51 is replaced with a provision recommending every child to be given an opportunity to learn error of his or her ways through corrective measures, while making it clear that the school shall not cause mental or physical pain to the child. The imposition and suspension from class are some of the corrective measures suggested. Similarly, Goa Assembly passed Goa Children's Act 2003 to ban the corporeal punishment. Liability of persons having parental and quasi-parental authority for children's tort. In United States of America, a parent is liable for harm caused negligently by the child while using family car, and this assumption of liability is normally agreed to by the parent while signing the minor child's driver's license application. In the case of General Insurance Company of America versus Falcon, the court considered whether an insurance company as subrogee could maintain an action under North Carolina's parental liability statute against the parents of a minor who had maliciously set fire to the drapes in the school auditorium. The statute provided damages for malicious or willful destruction of property by minors. Any person shall be entitled to recover damages in an amount not to exceed $500 from the parents of any minor under the age of 18 years, living with its parents, who shall maliciously or willfully destroy property belonging to any such person. While upholding the subrogee insurance company's right to maintain an action under the statute, the court noted that to allow the defendant to escape liability merely because the property owner had insurance would give him the benefit of insurance coverage for which he had not paid. It was observed by the court, I quote, "It is not apparent why the prudent foresight of the insured in protecting its property by insurance should result in a detriment to the insurance company. The granting of subrogation will reach an equitable result. To deny it would accomplish injustice." Unquote. Through common law principle, parental liability may be created by statute or by independently negligent behavior on the part of parents. For example, parental liability may be imposed where the parents entrust a dangerous instrumentality to their children or fail to restrain their children knowing that they possess dangerous tendencies. The Restatement of Torts section 316 provided that parent is under a duty to exercise reasonable care so to control his minor child and prevent it from intentionally harming others or from so conducting itself as to create an unreasonable risk of bodily harm to them if the parent knows or has reason to know that he has the ability to control his child and knows or should know of the necessity and opportunity of exercising such control. In the case of Lubez versus Wells, it was held that a golf club is not so obviously and inherently dangerous that it is negligence to leave child lying on the ground in the yard. Therefore, the parent was not held liable when his 11-year-old son accidentally struck a 9-year-old with it. However, in the case of Jarbo versus Edwards, it was observed that where the parents knew of their 4-year-old son's fascination with fire, they were held liable for failing to supervise and control him when he severely burned another child while playing with matches. Labonte versus Federal Mutual Insurance Company makes position clear that where the liability is created by statutes, the liability is absolute. In such cases, no negligence is required to be shown to exist on the part of the parents. The liability of parents is joint and several if the child is liable. Similarly, in the case of Slavin vs Byrne, the statute was strictly construed so as to impose liability on legally appointed guardian. So far as torts of strict liability are concerned, it would appear that minority does not afford a defense, provided of course that the ingredients of the particular torts are fulfilled. In India, a minor is a person who is below the age of 18 years. They can sue just like adults but through their parents, and can also be sued like adults if they are old enough to form an intention to commit a tort. A minor can sue for any wrong done to him through his litigation friend. A minor is generally not capable of being sued if he commits a tort, since he is incapable of reimbursing damage, but in most of the cases he can be sued just like an adult. Also, a minor can be sued for contributory negligence. Parents could be held liable for the tort committed by their children if they owed a direct duty of care towards their child while he committed the tort. They are responsible for their children's action the same way as the employers are responsible for the harmful action of their employees. While concluding, it may be said that in law of torts, the parents and persons in loco parentis cannot be held for wrongs because they have right to administer punishment and control the behavior and activities of their children or child in custody, so as to prevent them from committing any mischief to himself or others. Parents delegate such power to teachers when they are sent to school. Minor child can sue through their parents and can also be sued if they are old enough to form an intention to commit a tort. Similarly, there are special laws which provides protection to judicial officers with basic aim to enable judicial officers to administer law without any fear of being brought to litigation against them. With this, I conclude this lecture. Hope you have understood fully. Thank you.